Okay, hello everyone. Thanks for coming to our Next Gen Mentoring workshop. This workshop will be about intellectual property in mentorship and innovation. The presentation by Anna Nikšić from Tera Technopolis will guide participants to the fundamentals of IP, various forms of legal protection, and practical ways to identify what can be secure with research projects. Thank you. Anna, you have a word.
Hello to everyone. Just to share my screen. Okay.
We can see it, yes.
You can see the screen?
Yes, yes.
In presentation mode, okay. So, good morning to everyone. Summer is here and we are still working, dealing with this important and interesting subject about intellectual property. So, congratulations to everyone. My name is Anna Šarićšić, and I'm director of Tera Technopolis company. And Tera is a technology transfer office of Josip Juraj Strossmayer University, owned by the university, and also city of Osijek and Osijek-Baranja County. And today I'm here as IP Help Desk Ambassador. It's an intellectual property network established by the European Commission. And also I'm here as a representative of a PatLib Center established by the European Patent Office. And the third role of Tera is as a representative of the Enterprise Europe Network, which is also provides support in the field of intellectual property and the commercialization of innovations. So I'll be talking today about intellectual property in the mentorship and innovation, like Davor said, and I want to walk you through the fundamentals of intellectual property, the different forms of legal protection available to you, and some very practical ways to identify what can actually be protected within research project. So, as an introduction to the topic of our workshop today, I will show you a short video about the foundations of building research capacity. Just a second.
Today, we're going to talk about a really fundamental shift in how we think about research. It's about moving away from just seeing outputs and starting to see everything we create as powerful intellectual assets. So, to kick things off, let's just ask a question that gets right to the heart of what it's like to be a researcher or work in R&D. How do you personally define success in your work? You know, for decades, the answer has been pretty clear-cut. Success was all about hitting certain metrics, right? How many papers did you publish? How many citations did they get? And maybe, did you file any patents? That's been the classic scorecard for a long, long time. But this is exactly where we need to start challenging that conventional wisdom. Because that traditional view, while it has its place, is just, well, it's incomplete. I mean, think about it for a second. What if focusing only on those formal metrics means we're actually missing important parts? What if the most valuable things we're creating during our research are the very things that never even make it onto that old scorecard? To really see that bigger picture, we need to get our terms straight. And that brings us to a super important distinction. the difference between intellectual property and intellectual assets. Okay, so most of us are familiar with intellectual property, or IP. This is the stuff that gets legally protected. We're talking about patents for inventions, trademarks for branding, and copyrights for written work. It's formal, it's specific, and it gives you legal rights. But intellectual assets, or IA, is a much, much bigger idea. Think of it as an umbrella that covers all the valuable things that come out of your research, whether you can slap a legal registration on them or not. It captures the entire universe of intangible value you're creating. So here's the key relationship. IP is just one small slice of your overall IA. The best way to picture it is like an iceberg. The patents and copyrights, that's the tip you can see above the water. But the vast majority of the value, your intellectual assets, is that massive chunk of ice hidden beneath the surface, often completely unseen. All right, so let's do that. Let's dive below the surface and actually start uncovering some of these hidden treasures, the really valuable stuff that makes up the bulk of that iceberg. And this isn't just a theory. The reality is that most of the real-world value from research is found in the things that never get formally filed or registered. It's in the process, the know-how, and the connections you build along the way. And here's where it gets really practical. We're talking about things like the massive data sets you painstakingly create, the custom software you write, or the unique methods you develop. It also includes something called tacit know-how. That's the deep, intuitive expertise your team has that you can't just write down in a manual. Heck, even your negative results are an incredibly valuable asset because they tell people where not to go. So why don't we talk about these things more? Well, it's because they're invisible to the old scorecard. You can't count them like citations. But, and this is the important part, they are absolutely crucial for making a real impact out in the world. So recognizing these hidden assets is step one. But the second and really transformative step is adopting a completely new mindset to manage and actually use them. Let's dig into what that looks like. This slide nails the shift perfectly. On the left, you have the traditional publication logic, where getting the paper out is the end-all, be-all. But on the right, you have impact-oriented thinking. And in this world, a publication is just one strategic choice you can make. It sits alongside other options, like licensing your data, or open sourcing your software, or spinning out a new tool. Now, this new mindset makes us ask a question that feels a little strange in our publish or perish world. If sharing knowledge is so important, how could publishing it right away ever be a bad thing? And the answer comes down to strategy. When you publish something, you make it public knowledge. If you do that before you've even thought about all your other assets, you can accidentally close the door on future opportunities. It might prevent you from getting a patent later on, or from forming a commercial partnership that could have scaled up your impact. So let's pull all of this together now and really reframe how we look at the results of our research. If you remember one thing from all of this, let it be this. The results of your work are not just findings. They're not just outputs. They are potential strategic assets. And ultimately, your real-world impact isn't just decided by how brilliant your discovery is. It's decided by how well you identify, manage, and strategically deploy your entire portfolio of assets. That's what turns great research into lasting change. So, as we wrap up, I'll just leave you with this question to carry with you. When you start looking at your own work through this new lens, what hidden value, what unseen assets are just sitting there waiting for you to unlock them?
So thank you. And sorry, because of technical problems, we can continue. You see the presentation?
Yes.
Okay, so after this short video, we can conclude what is intellectual assets. And we can begin by widening our definition of what's actually valuable in research project. When people hear intellectual property, they usually think only of patents. But with this workshop, I want to introduce a broader concept, definition as intellectual assets. It's include all of the intangible outputs of your research and innovation activities, not just formal IP rights, but also data, software, algorithms, know-how, methodologies, experimental designs, research materials, and protocols. Many of your most valuable intellectual assets are actually non-protectable in a legal sense, and yet they remain absolutely essential for knowledge valorization, that is, for turning research into real-world value. So why does this broader definition matter? It's because it shifts our focus from purely legal protection towards the strategic management of all valuable research outputs, protectable or not. In the role of mentors, you should have in mind these issues. In process of mentoring, of course. So Horizon Europe give us a clear real-world example of intellectual assets governance. There are 4 concepts to know. First, foreground ownership. Assets generated during the project belong to whoever created them, unless the grant or consortium agreement says otherwise. The second one is joint ownership, when contributions can't be separated and a formal agreement should define use and exploitation terms. And then the third one, access rights. Participants grant each other access to foreground and background assets, often on a fair and reasonable or royalty-free basis. And the fourth one, the background IP. Assets that exist before the project, which must be clearly identified with access granted under definition conditions. Getting these 4 right early on is what prevents ownership disputes later. So it's very important to be aware of all these opportunities. The intellectual assets management lifecycle is based on 5 stages. The first stage is to identify intellectual assets and all research outputs early in the project, not just the ones that look obvious to be patentable. The second is to evaluate the potential and strategic value of each asset you've identified. The third is protection, to choose the protection mechanism that's appropriate, which doesn't always mean a patent. And the fourth is disclose, to share your results strategically at the right time and through the right channel. And the fifth one is utilization, to activate the actual valorization pathway, whether that's licensing, a spin-off, or something else. With this slide, we can take a closer look at IP protection solutions. IP protection includes a much wider range of strategic choices. Beyond the formal IP, rights like patents, trademarks, and registered design, you also have trade secrets, which are ideal for confidential know-how and internal processes. Also, we have open source licensing with strategic terms such as copyleft and permissive licenses, which can actually be a deliberate protection and dissemination strategy for software. We have also defensive publishing, deliberately publishing something specifically to establish prior art and to prevent a third party from patenting it later. And we have also data governance strategies that control who accesses your data and under what terms. And we have contractual protections built directly into your collaboration agreements. The key message here is that your protection choices must be aligned with your intended exploitation route. Not every asset requires formal IP protection, and the right strategy could be a combination, of course, of different solutions. This diagram gives us a useful map of the whole intellectual property landscape. At the top, we have the overall umbrella intellectual property, which is split into three main branches. On one side, we have what's often called soft IP. It includes trade secrets, know-how, and confidential information. And this branch is unregisterable. There's no office you fill it with and no certificate you receive. In the middle, we have industrial property, trademarks, patents, utility models, industrial designs, and so on. And this branch is registrable. You actively apply for these rights through the national or European office. And on the left side, we have copyright and related rights. It's a literary and artistic work, databases, which is automatic and unregisterable in most of the world, and it presents your, of course, original work. So, as you're thinking about your own research outputs, it's worth asking, does this belong in the registerable world, where I need to take active steps to protect it, or in the unregisterable world, where protection either happens automatically or depends on me actively keeping something confidential all the time? There are four main forms of IP protection, and the right one depends entirely on your strategy. There is no single universally correct option, of course. And the first option are patents. These protect technical inventions and solutions, and they require novelty and inventive step. They have a long, complex, and expensive registration procedure, what should be, you take in mind. And importantly, they require public disclosure of how the invention works. Second choice, copyright. This protects things like software, publications, and databases. It's automatic, and you don't need to register anything. And the third, trademarks and designs. These protect names, logos, visual appearance of a product, and they become especially relevant once a spin-off or a product is close to market. The fourth one are trade secrets, and it includes your know-how, your internal processes, and your formulas. There is no registration and no cost, but protection only lasts as long as you actually keep it secret, which is also a very hard work. This can be a great alternative when you don't need or don't want to disclose something publicly. So choosing the right form of protection is a strategic decision, as I mentioned, and as mentors, help your researchers think about which one actually fits to their situation, rather than assuming that the patent is always the answer. That kind of management support and advising support we call intellectual asset management. And to summarize everything mentioned earlier, I will show you another short video, and I hope with other technical problems, so we can continue with the video.
All right, let's dive right in. Today, we're going to talk about something that's at the very heart of research, but we don't always see it clearly. We're going to look past the usual stuff, the publications, to find the real, full value of your work. So let me start by asking you a question, and it's a big one. What is the full value of your research? I mean, really think about it. The way you answer this can honestly change your whole perspective. Now, for most of us in the academic world, the answer that probably jumps to mind is publications, right? Our success is so often measured by papers, by how many times we're cited. And look, that's important for sure, but it is absolutely not the whole story. A great way to think about this is the research iceberg. You know how an iceberg works? What you see above the water is just a tiny fraction of the whole thing. Well, that's your publications and patents. They're the visible tip. But underneath the surface, that's where the real mass is. We're talking about all the data you've gathered, the software you've built, the unique methods you've perfected, even the stuff in your head, that gut feeling know-how. And yep, even the negative results. All of that is incredibly valuable. So to really get a handle on all that hidden value, we need a bigger idea, a new way of talking about it that goes beyond just intellectual property. And that brings us to the concept of intellectual assets. So what are intellectual assets, or IA? Simply put, they're all the valuable things that come out of your research. And the key here is that it doesn't matter if they're formally protected by a patent or not. This is how we start to see the entire iceberg, not just the tip. Let's break down the difference between IA and IP, because it's super important. Think of your research as a treasure chest. The intellectual property, your patents and copyrights, those are like the big, flashy jewels that you put a lock on. But the chest is also full of gold coins, maps, and all sorts of other valuable stuff. That is your intellectual assets. It's the whole treasure, not just the locked up gems. So what does this hidden treasure actually look like? Well, it's the stuff you create every day. It's that tacit knowledge, that expert intuition that's all in your head. It's the practical know-how, that little trick that makes your experiment run perfectly. And then you've got the more concrete things, like the software you coded, the algorithms you designed, and those incredibly valuable data sets you spent months cleaning. Every single one of these is a powerful asset. Okay, so just knowing these assets exist is the first step. But the real game changer is when you stop seeing them as separate little items and start seeing them as part of a connected system. This is what we call thinking in portfolios. Portfolio thinking just means you understand that your research creates a whole web of connected assets. It's not just a checklist of a paper here, a patent there. No. That one patent, it was probably built on a specific data set. And that data set was probably analyzed with some custom software you wrote. And all of it was guided by the know-how you've built over years. It's all linked. And this is the most critical part, because they're all linked. Your assets are interdependent. What you do with one of them can create ripples or even shock waves that affect everything else. Here's a perfect example of those cascading effects. Let's walk through it. Say you publish a data set right away. That's a great thing for open science, and it's a super common practice. But that public disclosure could now prevent you from getting a patent on an invention you discover using that data later. And if you can't get a patent, well, potential commercial partners might lose interest, which could close the door on getting your research out into the real world. You see, one seemingly small decision kicks off a domino effect. So if it's all this interconnected and complex, what do? We can't just hope for the best. It's time to get proactive. We have to move from just recognizing these assets to actually managing them strategically. And that is exactly what intellectual asset management is. It's about taking the reins of your entire portfolio of research outputs. It's about strategically managing everything you create to unlock its absolute maximum potential and impact. So let's bring this all back to you, right now. Think about the project you're working on. What are the hidden assets you're creating? Go beyond the paper you're trying to write. What about that new piece of software, that unique methodology, that one-of-a-kind data set? The first step is just to see them, to make them visible. I want to leave you with this idea, which really sums it all up. Research outputs are not just outputs. They are strategic assets whose treatment affects later impact. Once you start thinking this way, you unlock so much more power in your work. The question isn't just, what am I going to publish anymore? The real question is, what impact am I going to create with my entire portfolio of intellectual assets?
So we can continue. If you have any questions, please feel free to ask. And to summarize everything mentioned earlier, there was so short video, but now we can continue with IP protection tools. We've covered the general landscape with previous presentation, and now we will shortly go through the individual IP protection tools one by one. Industrial property rights, as well as already mentioned, are patents, utility models, industrial design, trademarks, but additionally we have other rights such as geographical indications which protect the name of a product tied to a specific region, and some examples are Champagne or Parmigiano Reggiano in that context. The topography of semiconductor products is also intellectual property possibility, and it refers to the 3D arrangement of layers in a chip that enables its electronic function and can be protected as intellectual property. So how long does protection actually last? It depends entirely on which right we are talking about. Intellectual property rights grant you a monopoly on your creation for a limited period of time, and that period depends by the type of the right. Copyrights last 70 years after that of the author. Patents last 20 years from the date of application. Industrial designs last 25 years after registration. And trademarks can last forever, indefinitely, as long as you keep paying the renewal fees. So when you are advising a researcher or a student, you should keep in mind that the type of protection you choose also controls how long the competitive advantage will actually last. What can be patented? The invention has to meet the conditions of patentability. First, it has to fall within patentable subject matter because not every kind of intellectual creation qualifies. Second, it has also to be novel, which means not previously disclosed anywhere in the world. And the third, it needs an inventive step, meaning it isn't obvious to someone skilled in the field. And fourth, it needs, of course, industrial applicability, meaning it can actually be made or used in some kind of industry. So these four conditions come directly from the European Patent Convention, and they are exactly what will be checked through your patent application procedure. To reinforce this one more time, patent protection lasts up to 20 years from the filing date, and after that, the invention enters the public domain, and anyone can use it freely, so that should be in mind also. An industrial design may be granted in relation to the visual features of a product, like its shape, ornamentation, patterns, or configuration. And to qualify for protection, the design needs to show two things: novelty and individual character, meaning it creates a different overall impression on an informed users compared to what already exists. In terms of duration, industrial design protection can last up to 25 years in total, without possibility of extension, and should be renewed in 5 years period. So unlike the patent, which gives you one fixed 25 years term, a design rights needs to be actively renewed along the way if you want to keep it in force for the full period. A trademark is a sign or combination of signs used in trade to identify and distinguish the goods or services of one enterprise from those of another. So what can actually be protected as a trademark? It could be words, letters, numerals, pictures, shapes, colors, as well as any combination of these. And today, you can also register less traditional forms of trademarks too, such as three-dimensional signs, like the shape of the Coca-Cola bottle, for example, audible signs, like the Nokia jingle, or even olfactory signs, for example, the smells. For a sign to be eligible, it must meet several requirements also. It has to be distinctive, that means capable of actually distinguishing your goods or services from someone else. It must not be deceptive. It can't mislead consumers about the nature or quality of what you are offering, and it must not be poorly descriptive. You can't trademark a word that simply describes the product itself. So it must not fall into one of the exclusions provided by the law also, and it must be in conformity with public order and morality. In terms of duration, trademarks protection lasts up to 10 years initially, and it can last forever through renewals. Copyrights protects a concrete form of expression of the ideas. It arises automatically the moment you create the work, provided that it's original, of course. This protection lasts for 70 years after the death of the creator. And we have the part of soft IP. The soft IP is also important for researchers and as an impact of their work. Soft IP we can describe as confidential business information. In that category, we mentioned already know-how and trade secrets. In this group, protection is not achieved through the registration. There is no office to file with, and it falls under intangible rights. It's often also associated with other IP rights rather than standing entirely on its own, and it's free of charge since there is no registration fee. But also, while it doesn't involve long or complex registration processes, it does require appropriate internal management. And if I can say in other words, the protection is only as strong as your confidentiality practices, your NDAs, your access controls, your internal policies. If you don't actively manage it, all that processes, you don't actually have it. So you should be aware of this part and think and take aware all the needs should be set up. And to summarize everything mentioned earlier, I will show you the third video with perspective on how intellectual assets can be managed as interconsented system rather than isolated outputs. So as a whole solution.
All right, let's jump right in. Have you ever wondered why some truly groundbreaking research seems to change the world, while other work that's just as brilliant never really leaves the lab? Well, a lot of the time, the secret isn't just about the discovery itself. It's about how its intellectual assets are managed. So today, we're going to unpack that. We're diving into strategic intellectual asset management. And believe me, this isn't just boring admin work. It's the engine that actually turns great research into real-world impact. So, what do we even mean by intellectual asset management, or IAM? Okay, in a nutshell, it's about strategically managing all of your valuable research outputs. And I really want to stress that word all. This isn't just about filing patents. We're talking about a whole portfolio of valuable stuff, from raw data and software code to that unique know-how in your head and the new methods you've developed. It all has potential value.
And this is the big mindset shift, right? It's about moving from thinking, okay, we have some results, to realizing we have a portfolio of assets that are all connected. I mean, think about it. A patent's value might be completely tied to the underlying data that supports it, or a piece of software is only powerful because of the unique methods it's built on. Seeing those connections, well, that's the first step to unlocking their true potential.
Okay, so this leads us to a really fundamental concept, especially if you're involved in any kind of collaborative research. And that's the distinction between background and foreground assets. You absolutely have to understand this difference if you want to navigate joint projects without running into serious trouble.
It's actually a pretty simple idea, but it is so powerful. Think of it like this. You're cooking a big meal with a bunch of friends. The background assets are the ingredients each of you brings from home, the stuff you already had in your own kitchen. The foreground assets, that's the amazing dish you all cook up together. You couldn't have made the final dish without the ingredients, but they have totally different origins. And, as we're about to see, that has huge implications for ownership.
So let's just pause here for a second. Why are we making such a big deal about this? Why does this one simple distinction matter so much? What are the actual consequences if we just get it wrong? Or worse, just ignore it? Well, here's the thing. Failing to clearly define what's background and what's foreground right from the very start of a project, it can be a total disaster. It leads to huge arguments over who owns what, complete confusion about who's even allowed to use the results, and ultimately, it can just stop the whole project in its tracks. That brilliant idea you created together just gets stuck in a legal and administrative nightmare. And that leads us directly into the next major challenge. Because when you create those foreground assets together, that question of who owns what can get really complicated really fast. And that's when we enter the world of joint ownership.
So joint ownership is basically what happens when multiple partners create something new, and their individual contributions are so mixed together, so intertwined, that you can't just separate them out anymore. And in today's research world, where everything is interdisciplinary, this is quickly becoming the norm, not the exception.
And this right here, this gets to the absolute heart of the problem. The real challenge with joint ownership isn't the joint part itself. It's the lack of clarity that comes with it. Suddenly, you have all these questions. Who's responsible for maintaining this thing? Who has the right to license it out? Who's going to pay the patent fees? If you don't have clear answers to those questions from the get-go, you're not really collaborating. You're just setting a timer on a future conflict.
But look, the good news is this risk is completely manageable. The key is to be proactive with clear legal agreements. A really well-drafted collaboration agreement defines everybody's rights and responsibilities from day one. It spells out things like who gets to exploit the results, how costs and revenues get shared, and what happens if one of the partners decides to leave. And this isn't about mistrust. It's about building a solid, professional foundation so everyone can succeed.
Okay, this brings us to our third big concept, the strategic choice between protecting your assets and sharing them openly. And it's so important to understand that this isn't some simple choice between good and evil, like commerce versus science. It's way more nuanced than that.
This quote really just nails it. We have to stop thinking of protection and openness as being on opposite ends of a spectrum. They're not. They are simply two different, very powerful tools in your strategic toolbox. The real question you should be asking is, which tool is the right one for the job I'm trying to do?
And you can see here how they serve completely different goals, right? If your main goal is to create a spin-off company or license a technology to one partner, you're going to need control. That's when you reach for tools like patents. But what if your goal is to create a new industry standard or get your methods adopted by as many people as possible? Well, then an open strategy is a much more powerful tool. And honestly, some of the most sophisticated strategies are actually a hybrid. You protect a core piece of technology, but open up everything around it to build a community and an ecosystem.
So how do you actually decide? Well, it's not a gut feeling. It's a strategic process. And it really just comes down to these three simple steps. First, you have to assess the asset itself. What is this thing, really? Is it an invention, a data set, a process? Second, you have to define your goal. What impact do you want to have in the world? And third, based on that goal, you select the right strategy, the right tool or combination of tools for that specific job. So, we've covered these three critical ideas: telling the difference between background and foreground assets, managing the risks that come with joint ownership, and then strategically balancing protection versus openness. So now let's see how all of these pieces fit together into one cohesive system. Because here's the thing about strategic IAM. It is not a one-time decision you make at the end of a project. It's a continuous cycle that's happening right alongside your research. You start by identifying and classifying your assets. Then you evaluate their potential and their risks. Step 3 is where you make that crucial choice about protection versus openness. And that decision then directly influences how you can utilize the asset and, critically, how you manage its public disclosure, like through academic publications. It's a dynamic loop that just keeps repeating throughout the entire research lifecycle. So if you only remember one thing from this whole explainer, please let it be this. To truly maximize the impact of your research, you have to manage your intellectual assets systematically as an interconnected portfolio. This proactive, strategic way of thinking, that's what separates untapped potential from truly transformative, world-changing innovation. So I'll leave you with the final question to think about. Take a really honest look at your own work, your data, your code, your unique lab methods, even the knowledge that's just in your head. Which one of those hidden assets, the ones that aren't on a patent application, holds the most unmanaged potential for making an impact? Because there's a good chance that's exactly where your next great opportunity is waiting for you.
Now we can go back to mentor's role in this process. What is important in mentor's role? As a mentor, you should actually recognize what's worth protecting. I call this the IP audit mindset, and it comes down to 3 questions you should be asking early on. First, is the result novel and non-obvious? Before assuming something is patentable, it's worth doing a quick check. Has a similar solution already been published or patented somewhere? Novelty is a precondition for patent protection, so this really is step 1. And the second question is there commercial potential of the innovation? Because scientific value and the market value are not the same thing. Result can be scientifically excellent and still have no one willing to pay for it. And we are aware of that in many situations. So a very important question is who would actually buy or license this solution? And the third question is who are all the co-authors and contributors to this innovation? This might sound like a formality, but unclear ownership among partners and institutions is the single most common cause of disputes later on. And it is important to get this sorted out early, while relationships are still good and the stakes are still low in this phase. Here you can see a simple 5-step timeline. A research result, invention disclosure, patent application, conference or publication, and finally commercialization. Step 3, highlighted in gold, the patent application must be filled before step 4, the conference or the publication, and it is important because in the European Union and in the most of the world we operate under a rule of absolute novelty, unlike the United States, which has a narrow 12 months grace period. Unfortunately, in Europe, even the research's own prior disclosure can destroy patentability. And this is important to know. It doesn't have to be a full journal publication. It can be a poster session, a preprint, even a thesis defense that's open to the public. All of those count as disclosure, and all of them can permanently destroy your ability to patent that result. So the very important rule to remember is that the patent application must be filled before any public disclosure of the results. Let's look at the bigger picture, how IP protection fits into the journey from research to impact. Many of you will already be familiar with the technology readiness level, scale or TRL, which runs from 1 to 9, and it's widely used in Horizon Europe proposal to describe how mature a technology is. And TRL 1 to 3 is basic research. 4 to 6 is validation and prototyping, and 7 to 9 is demonstration and market entry. So now here is also a practical question I get asked all the time. When exactly should I file a patent? The optimal moment is typically around the transition from TRL 3 to 4. And why? Because if you file too early, you risk an incomplete or overly narrow claim, and you simply don't know enough yet about how the invention will actually be used. But also, if you file too late, you risk losing novelty through publication. Once your IP is secured, there are 3 main routes to commercialization. Licensing is one solution. When you transfer use rights to a third party for fee, it includes lower risk since someone else does the heavy lifting of commercialization. The second solution is spin-off. You found a new company based on the research. You have, in this example, higher risk and effort, but also higher potential upside and more control in further business. And the third, joint venture, partnering with an industry player and sharing both the risk and the resources also. Now we can focus on the specific kinds of challenges you may face as mentors, particularly within the context of EU projects like the one many of you are already involved. First, example, ownership with multiple partners. In consortium project, we can see it's a consortium agreement, but not just grant agreement, it's consortium agreement where IP ownership and background and foreground rights should be spelled out. And as a mentor, you should be aware of those agreements, check them if they exist, and that your mentee actually understand it early on, not after valuable results have already been produced. The second one is the university IP policies. This very enormously because some universities claim ownership of all staff and even students' inventions, others don't. And you need to know your own institution's policy before you promise anything to students or a partner. The third are NDAs and industry agreements. This is a simple step that's very often skipped because before any conversation with an industry contact, even an informal one, you should make sure a signed non-disclosure agreement is in place, because also off the record conversation still counts as disclosure. And fourth, deadlines and priorities. Conference deadlines and patents deadlines rarely align. So you should make an internal checklist to make sure everything is in order. In mentor's role, there's 5 questions checklist you can run through any projects with commercial potential. First question is the result novel and technically non-obvious? Second question, has the invention disclosure process started before any public presentation? The next one, is ownership clearly defined among all collaborators and partners? And 4, is there a signed NDA in place before talking to industry? And 5, has a commercialization route been identified? My suggestion is to run through these 5 questions at your very first meeting with a new mentee whose project has any commercial angle at all, and don't wait until results is already in hand, because by then it may be too late, and for some of these questions to matter anymore. There are 3 key messages to take from this workshop. The first one is that timing is critical. So think about protection before publication, not after. Novelty cannot be recovered once it's lost, and no matter how good your lawyer is. The second message, ask before you advise. Novelty, commercial potential, and ownership. These are 3 questions every mentor should ask at the very beginning of a project. And the third, connect with support organizations. You are not expected to be one-person IP department. And in that part, there are technology transfer offices, legal advisors, different EU programs that support this issue, like IPR help desk, PatLib network, Enterprise Europe network, and they exist especially to help carry this load. So you can use them as individual consultancy support, or you can use the training models they produce and train your students and mentees. For first contact, if you need help or advice, you can contact Tera Technopolis as a partner of faculty, and we can signpost you to the contact point at your country also. Or also you can directly search for contact representatives of your countries in IPR help desk network, PatLib network, or Enterprise Europe network, because all those networks have representatives from every EU country. So at the end of this presentation, I would like to conclude that intellectual property in mentorship and innovation comes with specific challenges, but also with many opportunities for learning, collaboration, and impact. The key takeaway is that effective mentors are not expected to have all the answers, but to guide, to support, and empower others throughout that process. So with this, I will finish my presentation. Thank you for your attention. And now I like to open the floor for questions, comments, or some reflections before we continue with the next speaker. Do you have any questions?
Please raise your hand and I will give you microphone permission. Heimo.
Yes, thank you. Thank you for the talk. I have a question for European research projects because there is already an example grant agreement that is provided by the EU, and I would like your opinion on that. Is the IPR stuff in that example grant agreement well done, or do you think it's not enough and we should do more?
It depends how much of background and foreground IP you have. So it's maybe better to make also a consortium agreement in that situation if the background of IP is complex.
Okay, thank you.
So you have in your example you have grant agreement.
Yes.
Yes. So that how I said it depends how much of a background you have, and if it's complex, maybe you should think about consortium agreement and to define it with more concrete. So, but probably we should make analysis of your concrete situation. But I'm open to give some additional advice after this workshop also. You can contact your partner and they will distribute your example to me.
Thank you.
Okay, any more questions? I have a couple of questions. You actually answer some of them in the end of the presentation. So patent must be claimed before any publishing, right? Even poster session. Also, you answered when is the right time to protect. You said somewhere between TRL of 4 and 6, right? But my question is, can patent be changed before, how to say, final version of the patent is accepted? Can there be any changes, or when you decide to protect it in TRL 4 to 6, it is set in stone?
So the advice is to start with the patent application in the stage of TRL 3 and 4.
3 and 4, okay.
Yes, because in that stage you have a prototype, and you have definition of your patent claims probably. But you don't have a big possibility of changes when you submit a patent application. So it's very important you have a possibility to fix patent application on administrative way. And the basic and the search of patent application should stay the same. So its advice is to really define the claims, define technology, and define the technical or process improvements that you think are inventions and that you think you would like to patent.
Okay, thank you. I have one more question. So if someone has a patent and later makes some publication, if someone makes something with that publication, based on that publication, can it do it? Does that patent cover those findings or not?
I'm sorry, but I'm not sure I understood the question. Can you repeat?
If someone has a patent and later published something based on the same patent, right?
Okay.
And if someone else replicate the data or something from that publication, is it legal or not?
No, it's not legal because you submit the patent application, and it's very important the date of submitting your patent application. After that date, when you are still in the process of getting a patent, you don't have it still, but you disclose your invention, and no one should use it in its own purpose or commercial purpose. So you are totally safe after submitting a patent application.
Okay, thank you. Mia has a question. Okay, mic is on. Mia.
Yeah, I'm here. Thank you. My question is, well, I suppose that if you want to protect your product, it has to be peer reviewed, like if it's data or whatever. How does that work without sharing anything publicly, really? Do you have to, pinpoint people that you want to kind of pitch your idea to and then ask for their professional opinion, or how does that work?
Okay, in that I understand what you're asking. In that part, it's important to have that NDA, non-disclosure agreement, to ask for a opinion or anything that it's important for you in the process of developing your project or idea or invention. So the crucial is that NDA. And all those things that I mentioned through the presentation, that you should be aware during the process when your innovation and your idea should be a secret. So
I understand. Thank you.
yes,
Yeah, well,
the result of that situation is NDA.
Exactly,
Right, with all the persons, industry, some experts in the field, and everyone that you present your invention.
Okay, thank you.
You're welcome.
Any more questions? Thank you, Anna, for your presentation. It was really nice. The next workshop is planned for September, so look at your emails. Anna, any last words?
Thank you for your participation, and if you have any questions, feel free to ask. Davor can be a contact person, so we are here to support your project and future activities. And congratulations to participate in these summer moments and still working. So thank you.
Okay, bye everyone.